Can the judge come in, please?
Sure.
There you go. How you doing, sir?
Good, how are you?
And I do not want to mispronounce your name, so I'm going to let
Alex Eisemann, I'll jump out.
you. Say it again?
Eisman.
Eisemann. Oh, I was saying Eisemann. Yeah, I already
Close
messed it
enough.
up. Yeah. So I want to welcome you to the show. Thank you for coming through. I think there are 4 candidates running for 2 seats.
Exactly, right.
Okay. So why are you one of the 2 candidates that should be elected in one of those 2 seats? And
well-
then you can pull your mic closer to you and
Sure.
talk right into it.
Well, I'm a progressive Democrat. I've been working on progressive causes my whole time as a lawyer for 25 years, more than 25 years, been representing indigent federal defendants. I was, in 2012, I was asked by the chair of the Westchester legislature, Ken Jenkins and Lyndon Williams and Pete Harcum, another member, to take on Rob Astorino, the former county executive,
Yes.
on some issues. The first one actually was not the child care case, which is the one I was probably most well known for. One was another one where he was abusing something called the Board of Acquisition and Contract. And it was a kind of a David and Goliath fight. Board wanted to change how Astorino was using it as a pocket veto to kill off progressive legislation. He overrode he vetoed the legislation that was supposed to prevent that. They overrode his veto, and he said, I'm still not going to do it. So they asked me to come in and to fight him and to try to get him to comply with the law, because the rule is generally, if you don't like the law, you comply with it until the judge says you can do something otherwise.
Right.
His approach was to say, I'm just going to do it, sue me if you don't like it. And then while that was going on, he wanted to raise the cost of child care. Again, the legislature had said you can't raise it more than 20%, the family share, the needy family share of that. And so Astorino vetoed that. And they overrode his veto, and he said, I'm going to do it anyway. So they asked me once again, can you jump in at the last minute to try to prevent him from doing that? And I got a temporary restraining order and kept that going the whole year, and he couldn't raise that. So I'm mentioning that because these are progressive causes I've worked on. And, as a judge, you're obviously going to follow the law. You're going to do the right thing. But there's a lot of discretion. You're a judge. You're judging things. You use judgment. So there are a lot of areas of the law where judicial candidates think, oh, I can't really talk about this. They think they're paralyzed by the ethics of running for a judge. But it's really not true. You can say a lot. You just can't say, as a judge, I'm going to do X.
Right.
But there are things like we're losing rights in Washington, right? And we have a state constitution. If I'm sworn into office, I'm going to be sworn to uphold both the federal constitution and the state constitution. If there is a right that's weakened in Washington, whether through presidential executive action or through the Supreme Court overruling something, you have the right as a state court judge to say, I'm finding this under the state constitution, and define it that way too. So I'm talking substance like that, and we live in an era where this kind of active judging, I'm not calling it activist, but active judging to try to do something about what's going on in society is important. And I bring those things to the table, both with my experience and my background and my skills. And I think that those are qualities that voters will want.
One of the things in Black Westchester we've covered extensively is criminal justice reform, and one of the things that we've told people that one of the most important positions you can vote for is that the judge position. I know that they've passed a few criminal justice reforms in the new budget item. Where do you stand on criminal justice reform?
Those are fantastic. New York was in the dark ages for a long time. The misdemeanor bail, I assume that your listeners are familiar with this somewhat.
Yes. We've talked about it extensively.
Okay.
Yeah.
So really that shouldn't have to be into a law. That is a judicial discretion. There are good judges make those kind of decisions, but it's good because judges cover in all shapes and sizes. It's good to have guidelines. It's good to have the judges who are going to be outliers in misdemeanor bail know that it shouldn't be appropriate in most cases, except if there's a history of bench warrants not coming up to court, people who have violence. It could be violent if they're charged with a violent crime. It could go out and do that again. So there are reasons to set bail in cases, but precious few in a misdemeanor, because most people don't get jail time in misdemeanor cases, and they come to court. The discovery, it used to be that it's still not fully in effect, but it was that you would, if you're going to trial, you wouldn't know what the witness said
Right.
until the witness is about to get on the stand. They're in the hallway, literally coming in the courtroom. You're handed the witness statement. You look
Right.
at it and you say, oh, wow, I didn't know that. I would have investigated that. Well, that actually looks like a defense, but you're going to trial. You can't do it then in there. So other states have open file discovery. New York has come very close to that now by just saying that those witness statements are given over very early on in the process, so you can actually do a thorough job.
Right.
And whether you're a prosecutor or you're a defense attorney or you're a judge, you want to see justice done. That means all the facts come out on the table. And with this criminal justice reform, they are coming out on the table, and it's a very progressive and good thing that finally brings New York in line with the more progressive states around the nation.
Right. And so there was the cash bail. That was one. There was several other items that
It was the primary ones of the discovery and cash bail. They're doing something with speedy trial as well.
Right.
Generally, most defendants think of that as a windfall. It is important to get. It is important to go to trial quickly. And I've had clients who are affected by a slow trial process where witnesses die, people's memories fade, and often your defense is lost. Very often, it's a windfall for the defendants who are often responsible for the delays. But those things should be harmonized. There should be common sense in the whole speedy trial aspect of that.
Right.
Yeah.
I did want to add that one of the most significant aspects of the speedy trial issue is that detaining a person has a coercive impact and is likely to make them to plea instead of taking the full trial, even if they deem themselves to be innocent.
There's that, because it's hard to put a defense together when you're in jail.
Sure.
And bail is designed to help people assist their counsel in putting together a defense. It's hard for, judges are human beings. If someone is a defense attorney, which I am right now, I can tell you that it is a goal to get a person out on bail, because someday when they're being sentenced, if they plead guilty or they're convicted after trial, to walk in the courtroom and say to a judge, I'm living my life, I'm living it well outside, I'm doing right by society, I've learned my lesson, go ahead and put me in jail if you think that's going to help me. Judges are human. They don't want to put you in jail if you're out. So whether that is, a principled statement or not, it's the reality of how judges react to the fact that someone they're facing is in jail. It's easier to say you're going to stay in jail than it is to say you're going to put you in jail. So strategically, it's something that defense attorneys want to do to get someone out.
Mhm.
As a judge, it's not going to make a difference to me. It doesn't make a difference to me because I dig deep into what's going on in a person's background, and I don't just look at it and say, what's the easy way out? I was a law clerk to a federal judge, and I have experience at just assessing things just on the merits, not because of some external factor like whether they're in jail at that moment.
Do you think the new reforms went far enough, or do you think there's more that needs to be done, and how do you feel about that?
Well, those reforms I think did go far enough. Now the Democrats are in control of the governor's house, the Senate, and the Assembly,
right.
and so they passed stuff which were important reforms which were not being passed for many years. There are other things that could be done. We could reform mandatory minimums, which are still a tragic thing. When people are charged with a high enough crime that they have to go to jail, tying the judge's hands. Again, this is the kind of thing that shouldn't require legislation to say, Judge, you need to give an appropriate sentence. Good judges should be able to do that on their own. And for 200 years of our nation's history, they did that until mandatory minimums came into vogue in the 1980s, and they're still federally, especially, and in New York, there are mandatory minimums that should be done away with. There are immigration reforms that are needed. This is federal, but there are a couple of things going on. About ICE showing up at the courthouses
Yes.
and taking people away. At least I've thought about this issue as whether there's a sort of a states' right aspect to this, that the federal government is coming and interfering with someone who's under the process of a state court, and whether state judges really do have a power to try to prevent someone from being arrested and affecting the course of their case. I don't know the answer to that yet, but it's an issue that's in my mind. Congress in 1996 passed something called IRA is the acronym for it, where they took away hardship relief for anyone who's convicted of something called an aggravated felony, which is defined under the federal statutes. That can include misdemeanors. So they took away hardship relief that normally would be applied to someone who has been convicted of a crime, aggravated felony, who is otherwise a lawful permanent resident of the United States. And the federal government now could just deport them. There's no defense to it. There is no hardship relief for someone convicted of an aggravated felony. that can be reformed because
Wait,
he
so
should give that back.
if you're a green card carrier or a resident?
Green card carrier.
Okay.
If you're not a citizen.
Right.
If you're a citizen, you're insulated from it. But if you are convicted of, let's say, a minor drug offense, it's a felony. Okay, all the drug offenses are defined as aggravated felonies. So the federal government, will start removal proceedens on you while you're in jail or when you get out.
I dealt with a little bit of that. I used to be a hip hop journalist, music journalist for a while. The legendary rapper Slick Rick was, he was I guess a green card carrying member, but lived here all his life. Raised his family here and everything. But then when he committed the felony and he went to jail, actually they didn't get him. They didn't send him out of the country. He performed on a ship, one of those ships, and once it left the U.S. with Tom Joyner cruise, once it left the U.S., they got him for illegally sneaking back in when he got off the boat, saying that he deported himself. Right.
That's a nice.
So he had to.
That George W. Bush said that.
Yeah. So he had to fight that for like over a year. He's free. He won. But I mean, that's when I first came upon that. He lived here all his life, knows everything here. His kids know it, and
Well, that was Congress in its wisdom, thinking that the way to deal with the problem of people committing crimes when they're residents of this country is to just send them off. And you get people who have never lived in the country. I had a client who was from Colombia. He left there when he was 6 months old, didn't speak Spanish, lived here his whole life, was a hardworking guy. He had some financial problems. He ended up getting involved in the drug business on some level. He pled guilty to it, and he was married to a woman who grew up in Long Island. They had kids here. He was threatened with deportation, and I at the last minute, really running to court in Newark, New Jersey, which is where the immigration facilities were, got a temporary restraining order just as they were about to take him to the airport, and kept that going, and finally got a case decided in the federal appeals court that covers New Jersey, Delaware, and Pennsylvania to change the law because in that circuit, which is the Third Circuit, the government was not allowed to deport people to countries where there was violence if the person who's being deported could show that the violence is sanctioned by the government down there. So in Colombia, there's violence, but it's not sanctioned by the government. Those are rebel groups. So I looked at something called the Convention Against Torture, found that there was some authority saying that the idea that if the government is turning a blind eye to the violence down there, that should be enough to prevent the removal of the person to that country. And I fought that, one in the district court level, one in the Court of Appeals, and he actually got his hardship relief, which had been taken away from him because he had the aggravated felony. So he was able to stay here.
What do you feel now? I know you can't speak on any specific thing, or even what you would do. I guess you can't speak on.
Try me. I might be able to speak on it.
There's been some local issues, local cases where black individuals have been killed by the police, and the judge refused to, prosecute them and do anything, and no justice was brought, and these families have been fighting for justice for several years. I mean, that's not just a county situation. That's a national situation. But we've had a couple of incidents here in this county as well. Right. Can you speak on any as far as I didn't mention specific cases. That's why just go ahead.
Or what would you do in your capacity as a trial court judge, for example, where you had to hear one of these rather controversial cases in which there was the death of a civilian?
The easy answer to that is that I would be fair and impartial. But that doesn't tell you a whole lot.
Right. But that's usually what I get. That's all I get. Yeah.
But that's what would be guiding me, because I'll answer that question fully in a second. But when I was a law clerk to a federal judge, it was the best job I ever had, because all I was doing was going to work, trying to do the right thing every day. So what's the right thing? Well, that's a little bit of slippery slope. To one judge, the right thing might be one thing, and one to the other. You always have to remember that in this case, you are an umpire calling balls and strikes. And I don't agree with the Chief Justice saying that about everything. But in this case, where it's a very close call, often, depending on which perspective you have, to the police who say, I can't take a chance, with anybody who's doing something, I could be killed, I have to overreact. They would say that. And to the community who says, come on, like Amadou Diallo, it's a wallet, not a gun.
Right.
It's something I think ultimately has to be put in the hands of a jury, not a judge, because you're going to have to get a consensus. You're going to have to get a majority vote on something like that. They're not easy questions sometimes. Sometimes it's easy. Some of the cases that have been in the news are simple. You know that the police officer's done wrong. Other ones are harder. And it really, for a judge to make that decision, if I have to do it, I'm going to do it, but I'm going to apply the law in that case. But I think a jury doing that, a grand jury doing it in the initial instance, and a jury doing that is the way to let the community have input into it. And if the community thinks that what the cops did are wrong, and the case law supports that, then the police officer should be convicted. And if not, the police officer should be acquitted. It's not easy.
It's funny that you said that, because a lot of these situations, since they don't go to court,
Yeah.
there's no case law. You know what I'm saying? Like there might be a settlement or something. But I know a lot of the African American community has a very big distrust in the legal system as a whole. When you see situations like where cops say, they feel for their life, there have been situations in New York State. One incident was a terrorist. He was a terrorist. He planted the bomb. They knew he was a terrorist. They were looking for him. They only found him because they was clearing this area and he was sleeping in his car. They were knocking on the window. He thought they had him. He then fired on the police officers. If the cops got any reason to shoot you, then he was taken alive. You know, the guy who went into the church, all those, they were taken alive. Unarmed black men with no weapon are just dead. You know what I'm saying? So that's all. There's a lot. There's not a lot of trust in the black community.
We don't have Jim Crow laws right now, but there's a legacy in our country of fear of the white community, of police officers, of the black community, hostility, and President Trump would say it works both ways, but the community's reaction to the police is often caused by the police's approach to the community. So integrating, and this is not my area of expertise, but integrating officers from the community from which they come is a good way to start with that, and training of officers. But at that moment where the officer fears for his life, officers come in all shapes and sizes too. You can train them as much as you want, but there's going to be some who are skittish, there'll be some who are racist, some who are too slow and they could be killed. Mm-hmm. It's a very, very difficult area, and all you can do is do the best you can do, looking at the law about what it means to be criminally negligent, what it means to be reckless, and as a judge try to apply that. A judge, by the way, will be called upon, even if it's a jury trial, there'll be a motion by the judge made for the judge to dismiss the case after the people have rested their prosecution case on the theory that the evidence doesn't rise to the level of a crime.
Right.
And I'll be called upon to make those kind of decisions. Those cautious approach is to let that go to a jury. But there'll be times that even I will be looking at the evidence and say, it's just not there. There's no reason why this officer, just like any other person in a courtroom, shouldn't face a jury verdict when the evidence just is not there. But it's a prudent thing to let it go to the jury and decide it afterwards, because it's like it or not, it's politically charged to take that case from the jury if they could actually decide it on their own.
Another community that hasn't always gotten a fair shake, and probably was the birth of the Me Too movement, women's sexual harassment and all that. That seemed to be, I don't know how big that is in Westchester County, but I mean, that's prevalent everywhere.
Seems to be big everywhere as far as I can tell.
Any thoughts or anything that you can add as far as from being a judge perspective on sexual harassment and that whole thing?
Women are a protected minority under the Constitution, just like people of color are under race, and women have been subject to discrimination. I've never been a woman.
Right.
But, I'm aware enough of how life works to know that women are subject to incredible harassment, and it's almost taken for granted in some circles. We have a president that doesn't have a particularly good example on that front, but those laws need to be applied aggressively and fairly, both aggressively and fairly, to try to change how society views how they can treat women at the same time.
Is there anything that I've asked you some questions I wanted to ask that I didn't ask you that you wanted to speak on, any topics or?
Yeah, I actually had a list so I could make sure I answered this question. I wouldn't just know. As a judge, I once had somebody tell me, and I've always repeated it, that in the world there are happy judges and there are angry judges. Angry judges tend to, when they have something unexpected thrown at them, they're not ready for it. They get angry. They're upset with the people in the courtroom. I'd be a happy judge, because the fact that I don't know what's going to happen is what's going to make the job interesting to me. So anything can come at me. I have a history of in let's say in criminal cases, multi-defendant cases, you get 12 defendants all on trial. They have different defenses. They're stepping on each other. I tend to be the conciliator in there. I tend to be the person who thinks through how can all harmonize this together. So I like it. I like the challenge of it. It makes me want to get up every day to go to work, not only do the right thing, but to have a challenge about what's going on. I am patient. I did a lot of, for many years was doing court-appointed work in the federal courts. I'm patient with my clients. I'm patient with judges and adversaries. Judges would actually seek me out when they had a difficult client, somebody that is just not handling their case right, is interfering with what the lawyer wants them to do. And the lawyer generally has good sense, not always. And so I have that history. And I want to be a judge to give people the experience, in addition to doing things like protecting our rights that we're losing in Washington, and hopefully through this primary, reforming the process by which we select judicial candidates. But I want to be able to have people have the experience in front of me as a judge that I want to have. A judge that's down the middle, a judge that's listening to you, a judge that's engaged, a judge that is as smart at least as the lawyers are in the room, and a judge that's working very hard to try to do the right thing. I think great judges do that, and I want to be a great judge.
If anybody hearing you, seeing you for the first time, want to know more about you, websites, social media, how they get in touch with you?
My website is my name, alexeisemann.com, ALEXEISEMANN.com.
Mm-hmm.
On Facebook, it's Alex Eisemann for County Court. As other guests have said, there's a big contribute button there. I can't ask for contributions, but races are expensive, and you can't win a race if you're not getting contributions. So,
Right.
if anyone wants to contribute, I won't say no. So I'm not asking for them.
Now, judges don't really have debates, right? You don't have like a judge debate.
We do. This whole idea that judicial candidates can't talk substance is not really right. I mean, but it's easy for a judicial candidate to say, I can't talk about this. It happens whether it's in the Supreme Court level in Washington, D.C., or even here. The world's sort of separated into three zones in terms of what your ethics are as a judicial candidate. You can talk about anything you've ever done in the past. You can actually talk about the issues of the day. I can tell you I don't like President Trump or his policies. I just can't say as a judge I'm going to do something.
Okay.
But I can tell you what I would consider doing. Things that like this issue about whether you move things to the state constitution. If there is a right that we consider ingrained in our fabric of society, let's say racial profiling, that's not allowed under the federal constitution. But suppose the Supreme Court decides that that's allowed. I'm not deciding it here, and I'm not sure. I'm not saying I will come out that way. But if there's authority and there's a basis to call that a fundamental right to be free from that kind of profiling, and that right can be found under the state constitution, I'm prepared to do that. I'll hear the sides of all the briefs of both sides. I'll consider it, but that's a power I know I have, and it's a power I'm willing to exercise in an appropriate case. So you can press judicial candidates. You can press me. I'll tell you where the limit is. Well,
I do, and since you're there, I have one more question for
Sure.
you. Can't speak specifically, but I've seen it not just in the city of Mount Vernon, but in some of the other municipalities where, say, like a city of Mount Vernon, there's a charter situation, and the two forms of government, the mayor and the city council, can't come to an agreement, and they take it to court. I've seen a lot of those situations where these things are being fought out of court where it's clearly written in charters and stuff. I guess you would see some of that if you were elected.
one of the things I'll be asked to do is to do Article 78, which is
Article 78, yes.
which is the way that if you have a public official who's not doing something he or she's supposed to do, or is doing something they shouldn't be doing, and Article 78 is the way to challenge it.
Mhm.
So,
Yeah.
I would be hearing those cases. I couldn't tell you about which one I'd be hearing or what I would do on it, but there's a process for deciding those things. That case I did with Astorino, childcare, and this Board of Acquisition and Contract, they were both Article 78 cases, and
Okay.
we used that. My clients were the Democratic members of the legislature. We used that to be able to force him to comply with the law that they had set down.
Mhm.
One, as a longtime activist, one issue that I'm curious to see how you, what your stance might be, would be the use of, we'll call it extra institutional measures on the part of protesters at a time when the nation seems to be embroiled in a deep crisis to try to, advance a progressive agenda. As you well know, one of the tried and true tactics of organizers, activists, is to create disruption. And very often the courts have looked rather dimly on some of the tactics that have been used. And the reason I asked this is because actually when I was a City University student and protester, one of the defenses that we invoked after we took over the buildings in the City University for 3 weeks was a kind of, I can't remember the technical,
Civil
but
disobedience.
yeah, and this was like a last resort. We didn't have any other kind of recourse. And at the time, it seemed somewhat novel. It was actually put forth by our defense attorney, Ronald McGuire, who's made a name for himself in progressive circles, been affiliated with the Lawyers Under Law. Yeah, I'm sure you know what that is, New York Under Law. In any case, I'm curious about what position might you take towards progressive protesters or, conservative protesters for that matter, who go outside the bounds of normal institutional, condone institutional practices in order to try to, advance their agenda. For example,
Yeah.
I mean, it is arguable that humanity, it's inarguable that humanity is not confronting an existential crisis in the form of global climate warming. And in my mind, the long-term consequences justify use of a lot of unusual tactics. I'd be curious to,
Well, for the first instance, those charging decisions are within the discretion of the district attorney's office here in Westchester. You would hope that District Attorney Scarpino would be sensitive to the idea that people are trying to exercise what's often a First Amendment right, and maybe they technically violate a law. Whether you don't have to charge everybody who's violated a crime, who has committed a crime with an offense. Everyone who has violated a statute doesn't have to be charged with a crime. So you would hope that he would exercise discretion and not do that. If he charges them, here's an area where I can't talk about what I would do, but there is an aspect of the discretion given to judges to have sort of interest of justice kind of
Right.
dismissals of cases.
yeah.
All I can say is that, is that I will, I know that is out there, and I know it's something that there's case law. It's not just the wild, wild west and you just decide, I think I'm going to dismiss this case.
Right.
But if it's appropriate, then I would dismiss it. If it's not, I wouldn't. And I don't know I can go any further than that.
Okay.
But you know what?
But you would be receptive
Well,
to the
yeah,
defense.
of course. You know what? But every judge should be. Of course
Right.
I would be. Because as a judge, you should be receptive to everything.
Right.
Everything that's within the law, you should do. It shouldn't matter that I happen to have a progressive background. Just like if someone came before me and they're conservative,
Right.
they're a landlord, where my heart right now is a progressive with the tenant. The landlord's entitled to have the law applied fairly too.
Right.
Judges, they put their thumbs on the scale sometimes to try to work it out. It's an extended negotiation in that kind of situation where the person's going to be thrown out. The landlord wants the tenant out. The tenant looks like they might recover. Judges tend to sort of work the process to help, because they are human, to help the person who's going to be thrown out. But it really you should be as fair as you can be. You should try to take that part of you, take it off your shoulder, that little person that's whispering to me and say, you've got a progressive background, and say, my job is to be fair in upholding the law and applying the law, but I'm not going to forget that person is on my shoulder. I'm not going to forget, what people who don't have the ability to get representation, that they have rights too, and they need their story told. So does the landlord. So does the prosecutor. But that's my job. That's the beauty of being that. And I'll add one thing. Because I'm old enough, I don't have to run for re-election. So federal judges are given lifetime tenure, so they don't have to worry about the impact of their decision. They can just be impeached. People who are running for judge for this 10-year term, who are going to face election, the day they're elected, they know 10 years from now they're going to be elected. And so their decisions, rightly or wrongly, as human beings, again, everyone's going to try not to do it. They're going to have that in their mind. I'm freed from that. I can do exactly what I think is the right thing. I'm not accountable to anybody if I win this election, and I will just try to do the right thing.
Any last words?
please come out and vote. Even if you're not in a community like Mount Vernon, which has a hotly contested race, or even in Yonkers, which has a contested race. I'm not sure how hotly
Absolutely.
contested it is. Please come out and vote. And if you hear my message and you think in this day and age that we need judges who are going to think like I am on the bench, and we're going to make a bench that's capable of protecting our rights, the same way that New York State has, that the governor has, just on some levels, then please come out and vote. Even if you don't care about the other races, come out. We're first on the ballot. There's a good reason for that, not just because of the fact that we're a countywide race. Judges are very important, and they're more important nowadays than they've been in the past. So
Absolutely.
please come out and vote. And no penalty if they want to vote for me. I'll take their votes.
Absolutely. Well, we
Okay.
thank you for coming and wish you well in your election.
Thanks very much.
And we're going to get into our